Let me welcome all of you. The time now is just 2 minutes after 10. Today is the 1st of August, 2022. I want to welcome the honorable members present here at M46 and those on the platform. To welcome the evidence leaders, Advocate Bauer and Advocate Mayosi. In absentia, I want to welcome the Public Protector and Advocate Mpofu. Hopefully they'll be joining us soon. I want to welcome members of the media with us. And last but not least, both the entire support staff that we have. But I want to welcome and thank all of you members of the public who continue to interact and participate in this process in your different platforms, whether it's 408 and so on. It's an important process. And I hope up to so far, you're able to make sense of what we're doing. So welcome. We want to start immediately. Today, we're going to finish up with the witness who was here with us physically. Today, he'll be virtual, Mr. Spello Samuel. And we hope to start with, to complete the cross-examination with Advocate Mpofu and the Public Protector team from now until just after lunch, 2 or 3. And thereafter, the evidence leader would, in summary, raise whatever issues they have. And if at that point, members have some clarities, I would allow that to happen. We're planning this week to, if we succeed, from today up until Friday, to have at least about 4 witnesses that want to go through. So it's going to be a hectic week, and we would want to start. It's getting much more intense, so we would want to do that this week, which means I'm going to be imposing more time restrictions, both to the evidence leader and the Public Protector team. And the same is likely to happen, that we want to at least have between 4 and 5 witnesses that we want to go through. I would just like if somebody can just check if have they joined now? Okay. Just to check the members of parliament who are there. If they can hear us. Honorable Lotfit, can you hear us?
Good morning, Chair. Yes, I can hear you.
Okay. Dis baie gelukkig. Ander mense word uitgevang.
We can hear you, Chair.
Thank you.
Can hear you, Chair.
Who was that?
Sewela. Honorable Sewela.
Morning, Honorable Suela.
Morning.
Clear,
I know, I know who I call up. Be on standby for when I call you. Thank you very much. I'm told that the Public Protector has joined us, as well as Advocate Mpofu. Good morning, Public Protector, Advocate Mkhwebane.
Good morning, Chairperson.
Thank you. And good morning, Advocate Mpofu. Can you hear us?
Yes, good morning, Chair.
Yeah, we were just waiting for until you joined, so I would have started about 5 minutes ago, but I realized that you were not on the line yet, so we just had to wait for that.
No, apologies.
Thank you for
we're having connectivity problems. We're fine now. Thank you, Chair.
Thank you, Advocate Mpofu. I just would have indicated that we're going to start with you from now until 2 or 3 o'clock, and then after we wrap up with the witness. But before I allow you to come in and start, I see the hand of Honorable Mautwe.
Thank you, Chair, for recognizing me. Chair, you just said we're continuing with cross-examination of Mr. Samuel. Now, you'll remember that last week we raised the issue of PP not having finished with the cross-examination of Mr. Samuel, and you said that they were done. And we said to you, according to the directive, before members of Parliament can pose questions, we should allow the PP first to finish her cross-examination. Now, it comes as a surprise that now today there's a turn of events, now that we're bringing back Mr. Samuel back again to continue with the cross-examination that you yourself, you said it was done last week. And members of Parliament are quiet. And when we call you, Chair, to order, to say that's not how you run this meeting, you throw us out of this platform, you tell us that we should not continue speaking. But we call you to order, rightfully so, Chairperson, because now you've interrupted the flow of the cross-examination. We are back. So it can't be, Chair. Please chair this meeting fairly and unbiasedly, because you are biased, you are unfair, and when we call you to order, the ANC and the DA members of are very quick to defend you. Where are they now that you've changed your mind? They must come here.
Thank you.
They must come here
Honorable.
And look ashamed.
Thank you,
they condoned this. Now today, you throw them under the bus.
Honorable Mautwe, to stop. Thank you for what you raised. But whatever that you are raising is really not a point of order. I've allowed you to go on and say what you want to say, a complete misrepresentation of what we're doing here. Last Friday here with Mr. Ibrahim Hassan, who was coming back after we would have concluded his testimony. So your point of order is not sustained, and I don't want you to continue making such comments as the chairperson is biased, because there's no bias here, and that must be on record. I want members, I'm not going to, I have no interest to entertain this any further, because I want to get straight to Advocate Mpofu to take the stand and begin the cross-examination.
But Chair, why did you stop me from finishing what I was saying?
Chair, on a point.
Honorable, you're out of order. I've asked you to stop. You're out of order.
Honorable Chair, on a point of order. On a point of order, Chair.
Honorable Dada.
No, it's Honorable Malema.
Yes, sir.
I'm recognizing Honorable Nodad.
Thank you so much, Chair. Good morning, everybody. Chair, please, man, we cannot be abused like this, Chair. There's a process that we're following. We've got directives that are set, and we're following those directives. And we can't be accused here of being biased when people are biased towards whoever they feel like they're biased to, whether it's the public protector or whatever the case may be. People must not get here in this meeting in the morning, get excited and make statements that are unfounded. And it's important, Chair, that we run this process based on the directives that we took. We had a witness that came back for further cross-examination last week. There is no difference to what is being done here. We're here to listen to people that are going to run the process if it's their own. It's important for us, Chair, to stick to those directives and not to be accused of being things that were not here, such as bias and so on, because we can stoop to that level, but we don't want to do that. We want to ensure that we give a fair process to the public protector and her team and the entire process that is led by Parliament. So please, Chair, you've made a ruling on this. Can you please continue with the meeting? Thanks.
Thank you, Honorable Nodada. Honorable Malema.
Chair, there's no one who's excited here because the Speaker was not given an opportunity to conclude a sentence. And you can't make a ruling on something you haven't had. So allow the Speaker to make her point and then make a ruling. Painful as it might sound, but we must listen to each other, because the way he was rudely interrupted is not nice. Whether we like what he's saying or not, she must be protected by Chair and by all of us here in this meeting. And people excited. And then when they call you names, you mourn like small kids. When you say people are excited, you're calling them names as well. And they will in return do the same. And then you're going to complain like grade 1 children here. So please allow her to conclude her point, and then you can make a ruling, because we're making a ruling on some. I didn't hear what she was saying. Please give her a chance and then make a point. All of us, including her, we want to proceed with this meeting. So please, thank you, Chair.
Thank you, Honorable Malema. Honorable Tlakudi.
Thank you very much, Honorable Chairperson. Good morning to you and my colleagues. Honorable Chairperson, I just want to repeat what you said earlier. When you opened this meeting, you said, today we are going to have Mr. Samuel as a witness to conclude with him later this afternoon. And you said you are going to give Advocate Mpofu to continue with the cross-examination until later in the afternoon. So I don't understand why now we are discussing this as if you said you were not going to give. My understanding is that the opportunity now is given to Advocate Mpofu and the PP. It's their time now. Then later in the afternoon, you are going to allow members to ask clarity-seeking questions. That is what you said. So there's no biasness on your side. I think we should proceed with the meeting because you are going according to the directives that we adopted as this committee. Thank you very much, Honorable Chair.
Thank you, Honorable Dlagote. Just before I go to Advocate Mpofu, just to recognize the last 3 hands, Honorable Zungu, Honorable Zungu, Siwela, Honorable Mailam, and Maneli. It's now 4. Thank you. 1 minute each, please. Honorable Zungula.
Thank you, Chair. I was actually waiting for you to call me properly by stating that I'm Honorable Zungula. I'm not Zungu. Chairperson, on Friday, there was an exchange when you highlighted that the cross-examination is done, whereas Advocate Mpofu and the public protector had raised the issue that they are not done. Now, we intervened, we raised this issue, and you were adamant that the cross-examination is done, therefore you are going to move on. You allowed members to interact and engage with the witness in accordance to the directives that immediately after the cross-examination is done, only then can the MPs interact with the witness. Now, on Monday, without the committee discussing and reaching a different conclusion, you are bringing back the same Mr. Samuel cross-examination that you said that cross-examination is done. So for me, it would give an impression that, number one, you need to apologize for what had transpired on Friday, because you were adamant on Friday that we as a committee will proceed because the cross-examination is done. And when we raised this issue, you did not want to change your mind. Or it would appear that you are taking instructions from somewhere, because akho mntu onothetha into ethile on Friday, then on Monday, their mind has changed. without the committee actually discussing and reaching a different conclusion. So we are raising this thing, Chair. You can't state that Mr. Hassan or Mr. Ibrahim, he was brought back and therefore that makes it okay. Because Upper, we can't be moving, directionless. Whereas when you like, you are going to bring a witness. When you don't like, the cross-examination is done. The committee must dictate the agenda and the program of this committee. And secondly, the committee must discuss whether to bring back another witness. You can't alone or taking instruction or influence from somewhere we don't know. You come back to us and
Thank you, Zungula. Your 1 minute is expired. Thank you.
Chairperson, wait, Chairperson.
Honorable Zungula.
Honorable spoke and Honorable Drakude spoke. You did not mention the issue of a minute. Why
I have imposed that minute, Honorable Zungula.
You did not impose
you, Honorable
it. Why is it when I'm speaking you are going to impose it? Why can't you be fair? Why can't you allow us to address you the same way? Why are you making different rules for me and different rules for the other Honorable
Zungula? You made your point. Thank you, Honorable Zungula.
I'm not done. I'm addressing you, limiting my time now.
Asking you to stop.
Addressing. Allow me to finish my submission, then we can move on.
Honorable Zungula, I've imposed a time limit. I want you to stick to it.
I'm addressing this time limit that is new to me, but it was not utilized to other people.
Honorable Zungula, I'm not going to continue with this dialogue with you. And I want to repeat.
I want to repeat,
Honorable Zungula. Honorable Zungula,
I feel you are unfair. When you are unfair, Chairperson, I'm going to address you.
I now recognize Honorable Siwela.
Chairperson, I am not done with my submission.
So I'm recognizing Honorable Siwela, Honorable Zungula.
Chairperson,
I will not continue with what you're doing.
I'm not going to leave the platform up until I'm done. Chairperson, I'm not done.
Go ahead, Honorable Siwela.
Let me continue with my submission. It appears, Chairperson, that you are taking instructions from somewhere else.
Just pause, Honorable Siwela. Honorable Zungula.
You are
Honorable Zungula, this is Honorable Zungula. This is the last warning I'm giving you.
Warning for what, Chairperson?
Honorable Zungula.
Warning
I'm
for
giving
what?
you a last warning.
I'm
I've
not
asked you
done
to
with
stop.
my submission. I'm not done with my submission.
You don't have to be done. I've imposed a time limit, Honorable Zungula.
Why on me only? Why not on the other members who spoke?
Okay, thank you. I've done my part. IT, please mute. Honorable Zungula.
I'm going to continue, Chairperson. We allow you to treat us in a way that is not consistent. If you are consistent, this would. But you are inconsistent, Chairperson. That is why I'm going to address you.
Chairperson. IT. Then I'm asking you now to remove Honorable Zungula. IT, please remove Honorable Zungula from the platform.
Remove me for what? For calling you to be fair.
Please remove Honorable Zungula from the platform.
For calling you to be fair.
Please remove Honorable Zungula from the platform. Honorable Siwela, you are recognized.
Thank you, Chairperson. Are you going to recognize me to finish as well?
On a point of order.
Honorable Siwela, you are recognized.
On a point of order,
Chairperson.
Chairperson, there is a point of order on the floor.
Thank you, Chair. Thank you, Chair.
Just hold, Honorable Siwela. Let me entertain the point of order.
Chair, you did not give the Honorable Zungula an opportunity to conclude his point, and that is going to be our biggest problem today. Allow members of parliament to speak, because this thing that you can sit at the corner alone, and when you are being challenged, you remove people from platforms. It's not going to happen. You are not going to preside over an unfair meeting and think that we're all going to allow you to do that. Allow us to discuss this matter and stop interrupting us. So please, we have to reinstate Honorable Zungula and allow Honorable Mautwe to conclude their input. And then we proceed with these meetings, because the concerns are on you, Chair. Instead of being open and fair to listen to what our concerns are, you are impatient with us and then you cut time. I mean, you just started from nowhere imposing 1 minute when you have not started 1 minute with the rest of us. He's right to say on a different, you exhaust the speakers, and then we said, moving forward, this is how we move. You don't say in the middle of a debate, and then we impose time. No, it doesn't work like that, Chair. Please, let's reinstate him and allow us to exhaust this matter, then we'll proceed.
Chairperson.
Thank you, Honorable Malema. I am now recognizing Honorable Swela.
Thank you, Chairperson. Thanks for the opportunity, Chair. I want to align myself with the Deputy Chief Whip, Comrade Doris Lakode, that we proceed with the directive given because the councillor is here with the PP to continue proceeding. If honorable members want to continue cross-examining the witness, we will do so. But what I'm worried about is the issue of name dropping that the ANC members are doing this. We are quiet because we want this process to flow smoothly, and we don't want that biasness. We don't want to be impartial, we want to be partial, because this is not a kangaroo court. That is our understanding. So to be given an opportunity to listen.
Thank you, Honorable Swela. The point is made.
We need to proceed. Thank you.
Thank you, Honorable Swela. Honorable Mailam.
Chairperson, I wish to address you on a separate issue, and it's a privilege, if I may. Chairperson, one of the reasons why we have these hearings is that we can see the persons involved, and unfortunately the public protector is not on a separate screen. Is there any way that we could get the public protector on a separate device so that we could be able to see her and her reactions to the questions and the comments that are made by the witnesses? Thank you, Chair.
Thank you, Honorable Mailam. I will attend to that.
No, we're not going to allow that.
Honorable please, Honorable Mailam, please hold back. Honorable Mailam, Advocate Mpofu, please mute yourself.
Okay, thank you, Chairperson. But we object to that suggestion.
Please mute yourself, Advocate Mpofu. I'll attend to the issue. Thank you. Honorable Ngola.
Thank you very much, Chair. I think I wish to draw the attention of the committee to Directive 6.3 and 6.4. Was it seems as though that members do not actually recall where you get this thing of directing members to stop speaking and equally imposing a time limit. And I wish to draw their attention that you draw that from these directives, Chair. And it's not about these blatant accusations of taking instructions and all those things. Was you're given an opportunity to direct this meeting, and fairly so, you do that. You have not only done that to certain members, you have done that to all of us. When you think that the point is captured, but the point is becoming repetitive, you then impose that we must stop speaking. So I wish, Chair, to plead with all the members of the committee, can we now proceed as you have directed the committee, that can you allow Advocate Mpofu to proceed with the cross-examination of the witness on stand? I just wanted to plead, Chair, with the members of the committee for us to proceed. Thank you very much.
Thank you, Honorable Ngola. Last one, Honorable Maneli.
Thank you, Honorable Chair. I want to join those that would ask you to proceed with the meeting, but I thought it's important to place it on record, Chair, that in your summary, you would have indicated this point. And we respected this as members of the committee because we would have advised before that some of the matters are matters for the back office. And this is what you indicated when you closed the meeting, that this is the matter that will be dealt with between the evidence leader and Advocate Mpofu in case we have to bring back the witness. However, the ruling you would have made earlier on that that matter was complete was correct because you had given time limit and that members needed to come at a particular point. So I just thought it's important to place that so that our quietness is understood that we have been on the platform and we have never left the platform until you made that summary at the end of the meeting. So we did expect this to happen. Of course, other things of casting doubt on your capability as the chair have been dealt with even on Friday. Thank you, Chair.
Thank you, Honorable Maneli. I was hoping that you are the last one. Now I need to give Honorable Lottridge so that I can make a and explain to Honorable Maute what I was doing.
Thank you very much, Chairperson. Yes, I'm in full support of the previous speakers. And I think it is important that we do remember that we have our directives, but over and above that, the rules of Parliament and what happens in the committee has not been negated or nullified. They are still in force. And therefore, you as chairperson, as presiding officer over the proceedings, can make the rulings, you can make certain decisions. So I would fully support that. Chairperson, also, Jen, then just another point that was raised earlier in terms of allowing the evidence leaders to question the witness again. That is ordinary procedure in terms of the evidence leaders to redirect after cross-examination. I can't see that that should not be allowed. Thank you very much.
Thank you very much, Honorable Lottridge. Let me just explain the following things as I am about to repeat the ruling, and I will start on the issue of Honorable Zungula. After persistently asking Honorable Zungula to follow the orders of the chair, I had asked, I'm on the platform and I'm addressing, please hold back.
Order, Chair.
I'm making a ruling, please hold back. I was saying, on the issue of Honorable Zungula, I had asked him to please, and I was trying to redirect him. I have removed Honorable Zungula from the platform, and that is in terms of Rule 70. And for completeness, I'm going to read the rule, and it says, if the presiding officer is of the opinion that a member is deliberately contravening a provision of these rules, or that the member is disregarding the authority of the chair, or that a member's conduct is grossly disorderly, he or she may order the member to leave the chamber immediately for the remainder of the day's sitting. The rules of the NA apply in what we're doing. I have even said to Honorable Zungula, I'm warning him. I've even asked that he be muted. He disregarded the authority of the chair as I'm presiding here. And so for that, Honorable Zungula is removed from the platform. He is not going to be returned for the rest of the day today. And I hope that that is very clear. I'm going to proceed to the next point. Honorable Maute would have raised his hand, raised what I thought was a clarification that she was seeking. When I was introducing the proceedings of the day to say today is about Mr. Samuel coming back and concluding a cross-examination in the same way that Mr. Hassan would have come back on Friday and concluded a cross-examination with the Public Protector's legal team led by Advocate Mpofu. That was what she was beginning to raise, was actually challenging what I would have said last week when I said the time limit that was given to Advocate Mpofu had lapsed at a certain point on Friday, and then allowed the members who are part of these proceedings to play their part. And so even as we closed the meeting on Friday, we indicated that there is still going to be a further opportunity, as we did with Mr. Hassan, for Advocate Mpofu to conclude the cross-examination. Because Mr. Hassan was the first witness, came back last week, Friday, and his testimony was concluded. We're doing consistently the same thing with Mr. Siphelelo Samuel. And so I was ruling Honorable Maut out on the point of the point she was raising was not relevant to what we want to do today, and that there was nothing wrong that this committee or its chairperson would have done. We were consistent with both the terms of reference, the directives, but we operate within the framework of the rules of the National Assembly in terms of the 9th edition of those rules. I hope the matter is clarified in that regard. The last point before I invite Advocate Mpofu, I had, because they are now on virtual, I then wanted to hear the public protector if she is on the platform. After I would have started, and both herself and her legal team were not on the platform. Later on, I was told Advocate Mpofu had joined the platform. When I asked the public protector to indicate if she's present, I did hear her voice. Now I just want to check again with the public protector. Public protector Advocate Mkhwebane, are you with us on the platform?
Okay, Chair, yes, well, I'm in the same room with her. I'll ask her to come so that you can see her.
I'm asking Advocate Mkhwebane, the public protector.
Chairperson,
I want to hear.
I'm
not asking Advocate Mpofu. Advocate Mpofu, you are a legal representative of. You are a legal representative of Advocate Mkhwebane. I'm now directing myself to the public protector of South Africa, Advocate Mkhwebane.
Chairperson, if you learn to listen, please. I'm saying she's in the same room as me. I'll ask her to come here so that you can see her. I'm assisting you.
Thank you. I wanted to speak as Advocate Mpofu.
Chairperson, I'm here. I'm in the same room with my legal team, so we are using one computer. Thank you.
Good morning and welcome, Advocate Mkhwebane.
Thank you.
All right. With that, I'm going to proceed, honorable members.
Chair, you had recognized me earlier. You said I should wait for you to finish and then you recognized me.
Advocate, Honorable Mailam, please continue.
Thank you, Chair. Chair,
No, Chair. You had recognized me. I spoke earlier and you said I must give you a chance to speak. Then you recognized me. Honorable Mayor was not anywhere. It was me after you, Chair. Allow me to speak.
There, I will recognize you when you have to speak, Honorable Maude. You don't
but
just.
How do you recognize me when you've already recognized me, Chair?
I will recognize when you have to speak. Thank you. Honorable Mailam.
Thank you, Chair. I had asked as a point of privilege that Advocate Mkhwebane appear on a separate screen and show us her face during the proceedings. It's common practice during virtual proceedings that Advocate Mkhwebane in terms of this hearing, but it's common practice that the person who is the center of attention should be visible at all times.
Okay.
And I'm asking that be the case. And ruling in that regard. Thank you.
Thank you, Honorable Mailam. As things stand, let me start there. Honorable Mkhwebane is not taking a witness stand. Let's start there. There's cross-examination being done. I am very happy as a chair that she's connected. She's online, and I have no problem when she's online. The advocate representing her would be sitting next to her, and I'd want to close the matter at that point. Thank you. Before I proceed to Advocate Honorable Maute, please.
No, thank you, Chair. You know you like to interrupt me when I'm speaking. Can you just be patient with me the same way you are patient with Honorable Mayhem? I'm equally a member of this committee. I'm a member of parliament. I've got every right to be here. Please don't make me feel like I'm a stepchild. So I was saying on my point earlier that the way you're conducting this thing, you're confusing all of us. You are going to end up being confused yourself because the directives is very clear that you allow cross-examination to finish. And when cross-examination is finished, then you take members of parliament. You decided to stop the cross-examination, you took the members of parliament, and now you brought us back to the cross-examination. I'm just trying to help you so that this mess does not happen in future, Chairperson. Be patient with us, allow us to criticize you, allow us to correct you when you are wrong, like you are wrong in this case. We would not be sitting here with Advocate Mbofu, a cross-examination, Mr. Samuel. This should have been the platform for members of parliament to pose questions to Mr. Samuel. But you are zigzagging and you think that you are going to follow your zigzag. It's not correct. And please correct yourself. We want to be part of this committee and I want us to continue fairly, but be fair to us, be unbiased, and let's run this process fairly. Thank you.
Thank you, Honorable Mautwe. I now proceed, and I'm going to recognize Advocate. Mr. Samuel, are you still connected? Mr. Samuel,
yes, I am. Still
Thank you, Mr. Samuel. Advocate Mbofu, the platform is yours.
Thank you, Chairperson. I hope you'll remember that this is eating into the time that you had allocated me. So
I certainly will remember that.
I'll remind you, Chairperson. Okay.
Oh, go ahead. I will take that into account.
Thank you, Chairperson. Good morning, honorable members. Good morning, Mr. Samuel.
Good morning, Advocate Bof.
Thank you. Mr. Samuel, we have to finish you today, so we're going to be moving quite fast with your cooperation because there's a lot to cover. And yeah, I just want to, I'll try and make it easy again like I did the other day unsuccessfully. So what I'm going to do, I'm going to give you a quick recap on some of the issues I think we have covered so that we don't, the problem when cross-examination is interrupted is that we might slide back and cover things that we have already covered. So I want us to move forward. So I'm just going to give you like 12 points of what I think we have already covered so that we don't have to go back there unless if you disagree with me. The first point is that you've considered that there was possibly no link between the phone call and the change of mind of the PP, correct?
That is correct.
And you've also said that there's nothing to indicate that the Friede report was discussed in the meeting between the PP and the Premier, the 15-minute meeting, correct?
That is correct.
And you've also considered that the undertaking that was made to expedite the Friede report that the PP was referring to in her email was made in the legislature, in the open, correct?
Yes, that is correct.
And okay, this one is a bit tricky. You have considered that there might have been good reasons to abolish the what do you call that thing? Think tank. But that one, I must agree with you. You made a qualified concession because you said it could have been continued virtually, correct?
That is correct, yes.
Right. Then you've also considered, I think this was from a member, one of the members, that the reach or impact of radio outreach could be larger than physical community meetings, correct?
No, that is not.
Okay.
That is not the
That's
case.
fine. Thank you. Yes, that's what I want, so that we clarify. When you don't agree, you tell me. All right.
Yes.
Let me quickly deal with that one then. You accept, don't you, that the community meetings were not abolished, but they were reduced to about 200 and something, correct?
That is correct.
And you admit as well that there was, you were told that there was going to be an infusion of radio slots as to complement the outreach program, correct?
That is correct.
And you accept, just as a general statement, that radio reaches more people than a meeting in one village. I mean, one of our stations, Ukhozi, reaches about 6 million people. So I'm sure you accept that.
I do accept that, but I'm qualified to say that it is a one-way medium. It is not necessarily interactive or leads to the acceptance of complaints. Yes.
Fair enough. But in this case, you know that one of the things that would be given in those radio interactions would be the hotline, or let me call it the toll-free number, correct?
That's correct, yes.
And therefore that would allow for more, you're quite right, for more dual communication, correct?
Correct, sir.
All right. Then we move on to the next issue is that yeah, you have not read the independent report. I think that's what you said. I brought it to your attention, but you are aware of the parts that I brought to your attention, correct?
Yes, that's correct.
And furthermore, contrary to the impression created in your statement, you actually have not read the committee rules, correct?
That is correct.
Okay, then the next one, regarding the birthday, you also considered that Mrs. Zwane may not have been invited to the birthday party, correct?
Could you repeat that?
I'm saying regarding the birthday party, you considered that Mrs. Zwane may not have been invited. In other words, you could not dispute the PP's version that he was not invited, correct?
Yes, that's correct.
Right. Then we also, I think we agreed that given the timelines, and I don't want to go into them now, the statement that the investigation was being swept out of under the carpet was not correct.
Yes, to the extent that it was eventually released, yes.
Yes, thank you. And then the next one was you apologized to her for calling her an aspirant prosecutor.
Yes, on the basis that
that was what you believed.
Yes, I believe she's going to take also to that effect that she was in fact the prosecutor. If that is the case, then yes, I apologize.
No, fair enough. And you also said that, I mean, in fairness to you, that's what you believed at the time. It was not out of malice.
Yes, correct.
Yes. And then you also apologize for insulting her intelligence, saying that that was not your intention, correct?
That is correct.
Okay. And then you also informed us that some of the information in your document, in your affidavit, your second affidavit, did not necessarily come from you, but came from the evidence leaders, correct?
That is correct.
Okay. And then lastly, you and I agreed that your leave to appeal in regard to your criminal matter does not suspend your conviction. In other words, that was the exchange you and I have, that as we are sitting here, although it's not nice, you are still a convicted criminal in the legal sense of the word, correct?
No, we did not agree, and we still don't agree.
We still don't agree.
Yes, I do.
Yeah, that's fine. No, that's your right. If you don't agree, that's why I'm saying then we'll clarify. Yeah. All right. You accept though that I think I gave you enough examples that I don't want to go into that. You accept that until a conviction is set aside, it stands. Just as a general statement.
Yes, I accept that.
Yes, and yours was a conviction for the criminal offense of assault, correct?
That is correct.
And it still stands, correct?
It still stands until it is ventilated because I'm challenging it, yes.
Well, yeah, but that's like saying nothing. It stands until the appeal is finalized, correct?
I would like to qualify that. See, when you say it stands, you create the impression that it is effective. And that is the part I'm disputing. It is not effective until it is properly confirmed or set aside.
Okay, well, I don't want to get into a big legal debate here. But you are forcing me to put examples. You agree that if you were actually sitting in jail while you are awaiting your appeal, you would still be sitting there?
No, the conviction was for 1 month. I would long have been out.
No, okay, forget that. I'm talking principle, Mr. Samuel. If the conviction was for 10 years and you had appealed it, you would be waiting for it, but you would still be in jail, correct?
Oh, correct, yes. If I did not apply for bail, yes.
Yes. Okay, that's fine. And you are aware, by the way, that when you appeal, have you appealed both the sentence and the conviction?
Correct, yes.
Yes, you are aware that it sometimes happens that when you do that, that's why we sometimes advise clients not to appeal, especially a light sentence, that it can actually be increased. In other words, you can, on the appeal, they can say you must go for 6 months in jail without the option of a fine. You accept that? That's possible?
Yes, I'm aware of that.
Okay, thank you. Right. Okay. No, that's good. Then those are the issues that I think we can then put behind us because we have found agreement on. Now, I want us to move forward, and I'm going to again to play fair with you. This time, I'm going to give you 5 statements, which, if you agree with, then we'll end the cross-examination. But if you don't agree with them, then we have to explore them. Yeah. All right. The first one, and again, we've covered this, and it won't fit into that rule because I know that you don't agree with me. But the first proposition that I put to you, and one of the members also put to you, was that you are a sexist who's not prepared to be led by a woman. I know you didn't agree with that, but you remember us having that discussion.
Yes, I remember the discussion.
Yes, and no doubt. Yes, and for the record, I'm sure you still don't agree. Okay, and then the second one was that I indicated to you that you have what one might call an exaggerated sense of your own comparative intellectual and academic abilities, in the sense that you felt that Advocate Mkhwebane was, or that you were better than her in the senses that you explained, correct?
Yes, you put it to me, and I disputed that and said I could have made better decisions than she did.
Yes, yeah, no, fair enough. Yeah. And you also, let's just explore that one quickly. I don't want to go back to, at least you've apologized for the intelligence part, but so let's deal with the academic achievements. You hold a B Proc, correct?
That's correct.
And that's it. That's the end of your legal qualification.
That is correct, yes.
Yes.
Excluding the certificate I referred you to, yes.
Yes, yeah. And Advocate Mkhwebane also holds a BProc like you, correct?
Yes, sir, that is correct.
Yes, except that on top of that, she has an LLB, which you don't have, correct?
That is correct, yes.
And on top of that, she has a diploma in corporate law, which you don't have, correct?
I don't have it, yes, correct.
And on top of that, she has a higher diploma in tax law, which you don't have, correct?
Correct.
Okay, so I'll just leave it there. I think it speaks for itself who is more academically achieved. You'd agree with that, correct?
Yes, I would agree that she has more academic achievements, but I would like to say, Advocate both in all fairness and in all humility and with respect. One can have as many degrees like a thermometer, but it does not necessarily translate to what I said about her.
Yes.
I just want to leave it at that.
No, that's fine. I mean, yeah, we're not talking about one. I'm talking about Advocate Mkhwebane. I'm saying, and you. So let's not talk about some ephemeral one somewhere. In this case, between you and her, she has these achievements which you don't have, correct?
I've considered that.
Thank you. All right. Because it doesn't help to have some potential, you know. We want demonstrated academic achievements here, and confirmed by higher institutions. But I think you get the point, correct?
I get the point, but in practical application of her work, has it made any difference?
Yes, it has. I know you have a different view, but
yes.
Yeah. So in other words, you think you would have done better?
I certainly do.
Yeah, I think that's our biggest problem in this whole cross-examination. But that's fine. So let's leave that then, the exaggerated sense of achievement. So the next issues, so those we covered the last time, I was just recapping on them. This is, I now have three premises, Mr. Samuel, which I'm going to explore with you. And I want you to I'll give you an opportunity. I'm going to demonstrate that your testimony is worth 0 and it should not be taken into account by this committee for the reasons that we've already given, but also because it is tainted by bias. And part of that bias is this unfair comparison that you make. I think one of the members also mentioned this, between Advocate Madonsela and Advocate Mkhwebane, which has no basis. In fact, it's just a sentiment that you have, you and others in our society. So you don't, I know you probably don't agree, but you understand what I'm saying?
I certainly understand what you're saying, but yes, okay. You're correct. I don't agree.
Sure. Fair enough. And I'm also going to say that your testimony is also tainted by what I'll call further criminality. Apart from the one that you were convicted of, that you've also made yourself guilty of perjury on at least 1 or up to 3 occasions, which I will demonstrate. I'm sure you don't agree with that either.
Yes, I don't.
Yeah. And then finally, I will also demonstrate that your testimony is really just like that of Mr. Kekana, nothing more than the ramblings of a disgruntled employee who only discovered his conscience when it was clear that you were facing disciplinary action. But you were quiet since 2017, 2018, 2019, and only in 2020 you developed some fake conscience. After it became clear that the institution was being sued for your assault of Mr. Siam. That might have been a coincidence. I'm sorry, sorry. You were trying to answer?
No, I was saying, I was going to say, I dispute that, and if you lead or you put evidence to me that disputes that, where I agree, I will agree. But so far, I don't agree that you.
No, fair enough. But at least you agree, surely, about the sequence that you were, according to you, you noticed all these things, or what Mr. Kekana would call oddities. But you kept quiet for all those years until it became clear that the company was being sued in respect of your assault. In other words, you only started to speak in 2020. I mean, just as a dry statement, there might have been good reasons or bad reasons, but as a matter of fact, you only started going public in 2020, correct?
I will deal with those, with it when you put it to me. But right now, as that statement, I do not. Yes, I spoke out in 2020 when I sent my complaint to the speaker, but that was not as a result of action being taken against me. That was part of the action had not been taken against me up to that point.
Yes, no, that's fine. All right. Now, thank you, Mr. Sambal. So that's okay. At least now I know where we agree and where we don't agree. Oh, yes, that's fine. So effectively, my statement is that you are motivated by revenge rather than some philanthropic sense of putting things right and all that you claim in your statement. Again, I know you disagree.
I will dispute that. Yes.
You dispute, yeah, sure. Good. Okay, now then we can start with. I think we've cleaned up where we are. Right. Now I want to start with. You would agree with me that the premise of your evidence about what happened in the past is really anchored, among other things, on this notion that you told the public protector at the inspection in loco that you wanted subpoenas to be issued against the politicians, in other words, Mr. Mkhwebane and Mr. Zwane, correct?
Yes, that would be correct.
And she refused.
Yes, she did.
And she told you that she didn't want findings against the politicians.
That is correct.
And that's not recorded anywhere. It was a conversation between you and her.
That's correct, yes.
Right.
Okay. Just before you proceed, Advocate Mbofu, just to remind Mr. Samuel, you are still speaking through the chair. You might be on air, but you're still speaking through the chair. And I just want to have that indicated. Thank you. Proceed. Sorry for disturbing you.
Thank you, Chair.
Thank you, Chair.
Right. Now, when were you seconded to Gauteng?
Chair, I was seconded to Gauteng immediately after the stakeholder engagement. It was in March 2017, yes.
In March 2017?
Correct, yes.
Effectively, you were starting in March 2017? I think the letter was in February, just to assist you. Yes, I think you are right. The letter was sent to you in February, but I just wanted to know when were you. It was effective on the 1st of March. Am I correct?
I can't recall the effective date, but it was definitely after the stakeholder engagement in the Free State, and that was so the effectiveness. I'm not sure whether it would have been backdated, but I certainly started in Gauteng towards the end of March.
Okay, good. So by the time the inspection in Loco happened, you were already working in Gauteng?
That is correct, yes.
And you were not, therefore, really not part of the investigation, correct?
I would say I was still part of the investigation because no one, I was not removed, so to speak, from the activities in the Free State. They still required me whenever they needed me. Yes, so I was really not completely removed from the activities.
No. I accept that. You're not. Nobody said, okay, you must never utter the words free again. Yeah. But you were effectively no longer on the ground in that investigation, correct?
That's correct.
Right. And in fact, we are still even checking whether you were even at the site inspection. What do you say about that?
I know I was definitely there. And any suggestion that I was not would, quite frankly, be false, Chair.
Yes. Okay. No, it's fine. We'll come to that. And assuming you were there, you would have been coming really as a spare wheel, correct?
I specifically asked whether I was required to be there, and that I think that that question I posed to the Office of the Public Protector, specifically to Frank Binde. Yes, and he confirmed that the PP wants me there. So yes. I was not a spare wheel. I was instructed to be there.
Okay, no. That's the point I'm making, Mr. Samuel. If you had not been now seconded in Gauteng, you wouldn't have had to ask Ephraim. Obviously, you would have to be there. The mere fact that you had to ask means that you knew that it might be that you're not needed, correct?
Yes, that was a possibility that I might not be needed.
Yeah, that's the only distinction I'm making. I'm simply saying you yourself had to ask, whereas before that you would not have had to ask. Ms. Celia didn't have to ask because she was part of the investigation, correct?
That's correct.
Yeah. Right. Who else was there?
Chair, from the Free State Office, my recollection is that Advocate Celia was there.
Mm-hmm.
Advocate Sisa Mlonyeni was there.
Mm-hmm.
Advocate Vincent Maseko was there.
Mm-hmm.
Yeah, I think that was the team from the Free State. And then from head office, I recall Advocate Matlawe was there.
Mm-hmm.
I can't recall, other than that, and the PP, of course, but I can't recall who else at this stage. I can't recall who else was there from head office.
Okay. Did you claim traveling money to go to this place?
Yes, I did.
And did you actually go?
Yes, I did.
Mm. All right. And your PA would confirm that?
Yes, I believe she would.
All right. Now, then assuming you were there for now, wouldn't you find it a strange behavior that seeing that, okay, maybe the word spare wheel is not nice, seeing that you are not no longer hands-on in this investigation, that you would have told the public protector that you wanted to issue subpoenas, which she denies?
Chair, I need to explain my circumstances at the time. Mm-hmm. As I've said, even though I was seconded to the Gauteng office, I was not removed because, in the sense that someone in my place was put to act in the Free State. It was left to me to then appoint whoever was acting, amongst the senior investigators. Advocate Celia would have been one, but not exclusively. They were rotating. And so, to that extent, I was still very much involved in the activities in the Free State, as perhaps will be shown by the email correspondence and so on. And so, the initial idea was that I was going to be in Gauteng for 1 month. Mm-hmm. But given the issues that I was required to investigate and the work that I was supposed to bring up to date and so on, it was extended to 3 months. Mm-hmm. And so I went back to the Free State at the end of June when I submitted my report. So it would not be odd of me to be involved and to be involved in the inspection and in any investigation of the Free Ed project within that time, because I was going to go back to the Free State and expected to be up to speed with the investigation and so on. So there was nothing odd.
Okay, but you know what I mean, Mr. Samuel. I'm saying I accept that for the sake of this discussion. But against the background that you and I have agreed on, you are now seconded to somewhere else. You even had to ask whether it would be necessary for you to be there. So let's not, try to dodge the fact that you are no longer centrally involved. I think you've considered to that. All I'm saying is that in the light of all that, wouldn't you find it odd that you, not the people who are now on the ground in the investigation, would be the person speaking privately to the public protector about your intentions to issue a subpoena to persons? If you don't find it odd, you just say so. But
yes, I don't find it odd.
Okay, that's fine. All right. And this idea of yours, you only communicated privately to the PP, you didn't communicate to Advocate Celiers or other people like that who were hands-on with the project, correct?
I may have, during discussions about the investigation, I'm sure I must have raised it with Advocate Celia and her team.
Yeah.
It could not have been my own thinking and not involve the team. So I'm sure I must have. I can't recall a specific date and time that I might have done that.
Yeah. The words I'm sure, they mean something different in English and in isiXhosa. Okay. When you say I'm sure in isiXhosa, you mean I'm not sure. So which one is it?
Okay.
You're saying you must have. I think that's what you're saying.
I must have. I can't say I'm sure
recall.
On a specific date. Yes, I recall that. Yes, I cannot recall a specific day that we discussed it, but it might have come up in one of our discussions.
Might have come up, or it might not have come up as well.
It's also possible.
Yes, thank you. So on that scenario, then, you are out there in Gauteng, you are an invitee for all intents and purposes. and you don't speak to the people who are on the ground, and you just tell the PP that you subpoenas to be issued, how probable is that?
It is probable. It is very probable. I did not have to have witnesses in speaking to the public protector. I know I did. That is a fact.
Okay. Okay. Now, surely then you'll find at least this one odd there. You've explained the process of how people are implicated get engaged. You've been there for almost 20 years. You had been there for almost 20 years, correct?
That's correct.
And was there a letter of allegations that had been sent to the Premier and the MEC at that stage?
I think there was, yes.
Where is it?
There were. Chair, I'm sitting here, I don't have that letter, and the file was sent to head office.
Okay. Is it possible that there wasn't such a letter in existence at that time?
No, it's not. It's not possible. Okay, I'm making a specific allegation that they were not cooperating with the investigation. That was not a thumbs up. I did contact them initially, and they just ignored me.
Yes. No, that's fine. We'll follow that. So you accept that if the committee is not furnished with such letters of allegation, then this whole thing, then we must just forget about it. Sorry, Mr.
I want to answer that. I mean, I've said the file was sent to head office.
Yes.
So if the file is still there, the letters should be in the file. But if they are not, I would understand why they're not there because of your line of questioning now, Advocate.
No, forget about my line of questioning. Let's just stick to the truth. Yeah. I'm saying, you're therefore saying it's not possible that those letters do not exist or were not in existence at that stage as in April, on the 10th of April.
Yes, it's not possible. They were there.
They were there. And those letters were specifically to Mr. Mahashule and Mr. Zwane about what?
About their involvement in the Free Dairy project.
Okay, you'll have to...
Let me, can I just add to that? There was, now that I recall, there were other unrelated investigations where we would conduct HODs, heads of departments, with because the allegations would have occurred in their departments. On one such occasion, I sent a letter to one of the HODs. I think it was the late Mr. Msidi of the Police Roads and Transport was the HOD there. And the response came from the Premier's office where he sort of admonished me in contacting his, what he called his HODs. He said the HODs in the Free State report directly to him and any communication to them must come to him and not to the HODs. So
no,
knowing that, yes, all right.
No, carry on, Mr. Asama.
No, so I'm saying the Free Dairy project was the brainchild of the Premier and was to be executed by the MEC in that department because it was relevant to agriculture. Brainchild, as in, I've made reference to the fact that the Premier and the MEC owned up and took ownership of this project. So that was why it was necessary to ask them questions. or to get their side of the story in relation to their involvement.
Yes, Mr. Samuel, we'll get there, believe me. I'm asking you a simpler question now. Whether you are saying, as a matter of fact, that as at that point, there were letters of allegations directed not to an HOD, to the Premier and the MEC specifically around whatever you're saying there was, whether there were such letters?
Yes, there were such letters.
Who wrote them?
I think to my recollection, I also wrote those letters. I'm not sure whether they were written prior to that by my predecessor, but I definitely wrote those letters.
Mr. Samuel, I want us to be at that point, the
Advocate Mpofu, you just cut when you said, Mr. Samuel, I want us to be, and then we lost you for a while.
Okay, thank you. Am I back now, Chair? Am I back?
You're back now. You're back now.
Thank you, Chairperson. I was saying, Mr. Samuel, I want us to be must-have, must-have here. I'm saying to you, the sequence is very simple. The investigation Mr. Samuel.
Yes, Chair, I'm here, but I didn't hear Advocate Mpofu.
Okay.
Completely disappeared.
Yes, okay. I don't know what is. You cut again, and then we missed what you were saying.
Okay.
He also missed it.
Yes. No, thanks. Yeah, it must be something to do with the connectivity. I'm saying, Mr. Samuel, I want us to be clear on this. I don't want the stories about this must have happened or might have happened and so on. Let me take you through the sequence. 2013, the investigation starts, correct?
That's correct.
By your favorite, Advocate Madonsela, correct?
The investigation started by Advocate Madonsela, began in 2018. The rest
2018, yeah. And by 2016, nothing has been, there's 2014, there's a draft report, correct? Provisional report.
That is correct.
That's November 2014.
That's correct.
Between 2014, 2 years later, nothing has really happened, correct?
Incorrect.
Okay, between 2014 and 2016, what actually happened in that 2 year period?
We pursued the investigation, and to that extent, we pursued it with the politicians as well.
In that 2 years?
Yes.
What? Okay, you're just telling us like...
You will recall, Chair, that I've testified to the fact that it was Advocate Madonsela's specific instructions that the role of politicians should be pursued, should be explored. The report was inadequate in that sense.
Yes.
So yes, the investigation continued.
Okay, so for 2 years, she was making that sentence that there is no involvement of the politicians. This sentence took a period of 2 years at her and to land on you. What else happened?
Well, the investigation continued. We tried getting subpoenas when we were not getting any cooperation from the politicians, and that was refused.
I see. So you asked Advocate Madonsela for a subpoena?
Oh, no, not Advocate Madonsela. No. At the time, the specific person that I asked for a subpoena was Advocate Mkhwebane.
Okay, Mr. Samuel, please listen to me carefully. We're talking about the 2 year period between November 2014 of the provisional report and the departure of Advocate Mkhwebane 2 years later in October 2016, correct? I'm sorry, of Advocate Madonsela. Yeah, Advocate Mkhwebane is going nowhere. Okay, yeah, sure, that's fine, Sorry, yeah, no, so I'm sorry, I made a mistake. Well, I'm talking, that's the 2-year period I'm talking about. You understand?
Yes, I understand.
Yeah, I'm saying in that 2-year period, other than uttering one sentence, which takes 2 seconds, I'm not happy with the absence of involvement of politicians in this report. What else happened in the 24 months? You know how long 2 years is?
Yes, I know how long 2 years is, Chair.
Yes. Tell us the highlights.
The investigation continued. We explored quite a number of things, including, speaking to people that we considered, or associations we considered to be experts that I referred to last week. And so it's not like that was, nothing happened, we just put the file away.
Yeah, I know something happened.
Yes.
No, I'm sorry, Mr. Saban.
We went on investigating that matter.
Doing what?
Without the file being in front of me to check the investigation diary and so on. I cannot tell you what was happening there, but the investigation was ongoing until it was, finalized and sent to head office.
No. Please, Mr. Samuel, I want you to tell this committee what Advocate Madonsela that you say was super efficient and you and her doing this investigation. What did you do between November 2014 and October 2016? What did you do apart from one sentence about unhappiness with politicians? What?
Chair, I believe I've answered this question. I can't answer it with specific detail of what we did. We investigated, we continued investigating that matter.
Okay, Mr. Samuel, let's break it down. That's meaningless, that thing of we investigated.
Yes, I think Advocate Mpofu, yes, I think breaking it down will help. Please break it down for thank you.
Thank you, Chairperson. Yeah. Did you revise the 2014 report in any way?
Yes, we did.
When did you do that?
We did it between 2015 and basically when I started getting involved, with it, there were quite a number of drafts that worked on. And that means we did revise that report.
Where are those drafts?
They're in the file, most of them.
What happened to the rest? What happened to the others? You say most of them. What happened to the others?
Most, if not all of them, must be in the file. I also had some in on my laptop. So they are there. We have referred to them.
Okay, can we then leave it at this, that nothing of any significance happened because by the time Advocate Mkhwebane got into the office, she was given the November 2014 draft. So there could not have been anything of any that was worth any noting.
I do not agree with that.
Okay, we'll request the evidence leaders then to give us the full file. And you're saying we will find all these drafts you are talking about there?
Yes, we will.
All right. Just pause, Advocate Mpofu. Just pause. Advocate Bauer.
Just to place on the record that our endeavors to get the full file out of the Office of the Public Protector was not successful. It could not be found anywhere.
Okay, thank you. Proceed, Advocate Mpofu.
Thank you, Advocate Bao. Well, there you are, Mr. Samuel. It looks like your drafts have evaporated. Okay, so there's nothing that you can tell us just from your own memory as the person, but assuming we won't find these drafts somewhere. There's nothing of significance that you can say, we did this, you did not do an inspection with Advocate Madonsela, for example.
No, I did not do an inspection with her.
You did not issue any subpoenas?
No, I did not. But that is not to say that with my predecessor, she may not have done an inspection. I can't speak for that period. I don't recall that I know that there was an inspection prior to that was done by the team. I don't know with who, but I'm speaking now with my involvement since 2015. I had not done that with Advocate Madonsela.
Yes, I'm talking, well, I can tell you for free, the only person who did an inspection in local at that level was Advocate Mkhwebane. In that 3 years, Advocate Madonsela did not do such an inspection. You agree? At least not that you know of.
Yes, if you're telling me that is the case, I can't confirm or deny that. I can't dispute that.
Now, you agree that 3 years actually is a very long time. I mean, you can finish a degree in 3 years. And nothing of any significance had happened. Is that your evidence?
That is not my evidence. That is your assessment, Chair.
Yes. Okay. Can you refute my assessment? What apart from the report and the complaint about politicians, what else happened?
I have stated that I cannot recall with specifics over that period.
All right. That's fine. And yet, with Advocate Mkhwebane, within 3 weeks of her taking office, she was inquiring what's happening with this Fred matter, correct?
That might be correct, yes, because it was part of the handover report. It was there, yes.
Yes, it was part of the things that she found just sitting there and not being attended to. And then within a few months thereof, there was movement. She was already cracking the whip and asking you guys to be on the ball, run about March, which is March 2017. That's about 4 or 5 months after she has taken over. She was making inquiries about Section 79 notices and that kind of thing, correct? At least from the emails. Do you agree?
I would agree.
Yes. And within, in less than a year after she had taken over, the final report was out, correct?
Yes, between 2017 and 2018, yes, it was less than a year, correct? Yes.
Yeah, actually, it was something like 9 months or 10 months, correct? But the report was out by the end of August.
March and February, it's just, by my calculations, that's 11 months, Chair.
No. I think you're calculating. I'm saying Advocate Mkhwebane started working there in October 2016, correct?
Correct, yes.
By the end of August 2017, the report was out.
No, that's not correct.
The final report was not out by the end of August 2017?
It was out in February 2018.
No. Okay, maybe let me put it this way. The report from, you're talking about the public report. I'm saying the report from the team, from Advocate Silier to the final report being sent to the public protector was out by the end of August 2018.
Okay. Yes, that is correct.
I agree. Okay. All right. And then within, that was my next point, within 15 months of her being employed, the report was out in February 2018, correct?
Correct, yes.
So this thing that had been sitting there for more than 3 years was moved within a period of about a year to completion, correct?
That is correct.
Okay. Now, you agree that now let's go back to what you and I were discussing, which is your so-called request for subpoenas, which I was saying is improbable. Yeah. You accept that if there were no letters of allegations, it would have been improper to issue subpoenas. You know about what was called the 3 strike rule.
Strikes rule. Yes, I know about the 3 strikes rule. And your question that it would have been improper. Look, it would have been. Yes, it would have been odd and
premature.
Yes. Premature. Yes.
Yeah.
Yes.
Okay. Yes. Yes. And
just Advocate Mpofu.
Yes, sir.
Just hold it there at premature, and we'll take a 15-minute break, just so that you can come in after that. We'll be back at quarter 2. Unfortunately, we can't send you a virtual tea, but we'll have tea.
we'll make do without. Thank you, Chairperson.
Thank you. Let's pause until quarter to 12. Thank you.
Recording stopped.
Back.
Advocate Mpofu, you back?
Yes, we're back, Chair. Thank you. Thank you, Chairperson. May I continue?
Please go ahead.
Thank you.
Please go ahead.
Thank you. Mr. Samuel, we stopped at the point of declaring that the subpoenas would have been premature. We were speaking a language that the members might not know about. Can you explain to the members what the 3 strikes rule that you and I were referring to is or was?
Yes, Chair. The 3 strikes rule was that we first sent a letter of inquiry to the person either implicated or the person that can assist the investigation. And if no response is received, we then send a reminder with a tight deadline. And if that is also not adhered to, we then use whatever powers we have to force or to enforce compliance. It can either be by subpoena or any other means that are at our disposal, including but not limited to perhaps issuing of a warrant if the information is perhaps there, or we suspect that it is there at the particular premises.
Yes. All right. So that's what I'm asking you. Why then would you have defied the 3 strikes rule and just make this private proposal to the public protector for the issuance of subpoenas when the 3 strikes rule had not been complied with?
Chair, the 3 strikes rule is not necessarily prescriptive that it should be done exactly, that way. I mean, in a case, for instance, like this one, where the failure to comply came from politicians, that, it would be the public protector that would need to enforce the 3 strikes, because any further action, which is a departure from a normal approach to the politician, would have to be enforced by her, or at least under her hand, either a letter saying to the politician concerned, you are not complying or you're not assisting our investigation, and so we require you to respond within X time. So it was not for me to enforce it, but I'm not saying that, and by that I'm not saying that it was up to the public protector to do. I would have had to bring it to her attention and perhaps would have had to consider the 3 strikes rule. But, it didn't cross my mind at the time. I felt that given the length of the time that the investigation had been going on, we just needed to go and issue a subpoena.
Yes, but this is the point I'm making, which I'm going to argue, Mr. Samuels, and I'm putting it to you in fairness. This whole thing just doesn't make sense. Here you are, I've already said this, you are no longer involved, has to be involved, you are invited on your version. The public protector doesn't even remember you being there, but that's a matter we will deal with, because we are being frustrated by the public protector's office in getting information where we can conclusively make this statement, but we're working on it, Chairperson. But I'm saying it still doesn't make sense, because you are outside there, you come, you have some private discussion, you don't speak to the people who are involved in the investigation, and you defy the 3 strike rule and say to the public protector, she must now invoke a 1 strike rule and go straight to subpoenas. I mean, does that make sense even to you?
There was nothing strange with that, Chair.
Okay, on what basis were you, I'm sorry, were you still talking?
No, I'm saying there's nothing extraordinary or there's nothing strange with that. It is what I felt needed to be done at the time. And as I said, the 3 strikes rule was not prescriptive. It was just a guideline.
Yes, but so you were asking the public protector to commit an illegality, because what would happen if she had listened to you, issued the subpoenas, then she goes to court and they say you did not apply the 3 strikes rule. You just somehow issued subpoenas against people, terrorizing them.
Chair, there would be nothing illegal about that. It would just be one of the means by which we exercise our powers to secure information and cooperation.
Are you being serious? Have you ever heard of a situation where a subpoena is issued as the first resort without any having requested the person? Is that, you're saying that's not illegal? Where you just subpoena someone without having, okay, is it fair, do you think? Sorry, Mr. Saman. I wanted to say that, you know what a subpoena is? A subpoena is an instruction for you to appear somewhere on pain of going to jail. Can we start there? I mean, we just start by saying to someone, look, you must come and see me next week, otherwise you're going to jail, without ever having asked them. Even this committee, with all its flaws, says that you have to ask the person. That's why we did with the President Ramaphosa. We had to ask him voluntarily to come to testify. Then he wrote us last week, he says, no, he's not prepared to do so, and now we're going to subpoena him. But if we had just subpoenaed him, do you think that would have been fair?
Perhaps it would not have been fair, but coming back to our situation, to my situation here,
yes.
It was not the first time that we had written to the politicians. It might not have been 3 times or 4 times, but it was definitely not the first time, which is why I was asking for a subpoena.
You wrote to them about what, Mr. Samuel? Let's please, man, just assist us here. Did you ever say to those politicians, you are suspected of maladministration or wrong, whatever you call it, corruption, all those things, directly, not, and I'm not disputing the fact that they would have been aware that the HOD had been investigated by ENS and so on and so on, and the Auditor General. I'm not talking about that. Did you ever write letters to the MEC and the Premier saying, now you are implicated yourselves, not indirectly?
I would not have used the word that they're implicated. I would have said we are investigating this, this project or allegations related to this project.
Yeah.
And this happened under your watch, both as MEC and as the Premier. Yes. And so we would like you to furnish us with whatever information is relevant, and where we wanted specific information, we would then state in the letter what it is that we want them to assist us with.
Yes.
And any implication then after the investigation would have come out of if we're going to make findings implicating them, then it would have come in the Section 7(9) letters.
Yes. So at least we agree, you and I, that until this current public projector got into office, the MEC and the Premier were not implicated parties.
Yes, they were not implicated by any direct or indirect information.
Good. And the first time, actually, that there was any suggestion of their being involved in maladministration was around about, let's say, between March and June 2017, when the current public protector started cracking the whip on this report, correct?
Yes, it's possible. Yeah.
No, it's not possible. You know it's true, Mr. Samuel. Please.
No, if you say that it's true and I know it, and I personally, you're saying, to me, and
Okay.
I don't agree.
All right, fine. Let's make it easy. Advocate Mkhwebane took office on the 16th of October 2016, correct?
That's correct.
Before that date, were the politicians ever implicated parties?
Not by any direct or indirect information.
Correct. So then what's the problem? So the first time that they were even issued with Section 79 letters was after she took over, correct?
That is correct.
Yes. So this notion, during the time of Advocate Madonsela, never even issued with those notices, correct?
I believe so, yes. They were not issued with those.
Yeah, you believe so. All right. Now, was there ever a sense that Advocate Madonsela, to put it kindly, was obsessed with this issue of involving politicians, whether there was evidence thereof or not?
No, I wouldn't say she was obsessed. There was no such sense that I could make out of her.
Okay. Was there some...
There were allegations, certainly, in the media about the fact that this project happened under the watch of the two politicians. And to that extent, we could not, or at least she could not ignore that, and which is why she insisted that we should look at their role. And up until then, the only implication that was there was against the Premier, I think, to the extent, or either, HOD, but I think it was against the Premier, to the extent that flowing from the AG report, they had not taken action against the HOD.
Disciplinary action, no, fair enough.
Yes, disciplinary action, yeah.
Yes. No, but that's not what we're talking about. That's not what you were obsessed with as well. You were, when you were saying the public protector must issue subpoenas, it was not about that. It was about something bigger, correct?
Yes, that's correct.
Yes, and that something bigger had never been the subject of any letter to the Premier or the MEC, correct?
That something bigger was about their involvement and their ownership of the project. That was taken. That was the issue. That was the issue that I had raised in the letters to them.
Okay, so you had raised issues about their direct involvement. Is that what you're saying?
That's correct. Yes.
And these are the letters that we are missing now.
The letters that I, sitting here, cannot produce, Chair, but I know they were in the file, and that file was sent to head office. So if anyone had control or has that file, it's either head office or I don't know. I believe perhaps the public protector might have it.
Well, the public protector is suspended, so she has no access to anything to defend her. I've just told you that she can't even get the proof that you were not at the inspection local. We're still trying to find that.
My response, Chair, is that I was there at the inspection in local. The file was sent to head office, and sitting here, I also don't have control. And taking what the evidence leader said earlier on, that despite their requests and for the file, they did not get it. So I don't know who has it now.
Okay. Let's go to page 2221. It's SS9. Are you there, Mr. Someone?
Almost.
2221.
All right. Yes, I'm there.
Right. This is using the timeline that I was telling you about. This is 3-4 months after the PP has taken over. And this is the period where I'm saying she's now trying to dig what has happened with this file that has been lying cold. And this is Mr. Mkhwebane writing to the PP. Dear PP, the attached are draft documents which relates to the Freire matter as raised by Minister Zwane yesterday, and I think either in Parliament or in the public domain. These documents have been going to and fro. Okay, you agree with that? The documents have been going to and fro in your under your watch. Yeah. Okay. And then it says, because your predecessor, that would be Advocate Madonsela, felt that Free State did not address the issues. Free State means you and your people, correct?
That's correct, Chair.
Yeah. Did not address the issues that were raised with her. I don't know by whom. But obviously someone else had raised other issues other than the investigators, correct?
Chair, can I ask your indulgence to go back to the previous question, where Advocate Boff says the Free State would be me and the team?
Yes.
In relation to this letter, I'm just looking at the date now. That would be the team, certainly, but that would exclude me. I only came in after I transferred. Oh, sorry. Yes, no, that would be me. Sorry, my apologies. That was 2017. Okay, I thought it was 2015. Sorry.
No,
yes,
it was 2017. No, yes. I forgive you. That's fine.
Thank you.
Okay. So and then it says, yeah. So you and your people did not address the issues that were raised with her. That was my question by whoever. We don't know who raised the questions with her. Correct?
That's correct.
But it was not raised by you, by the investigators.
That's correct, yes.
It must be some external forces.
No, I don't understand.
I mean, okay. It was not raised by the team that was investigating. It must be someone else. We don't know, but it's someone external to the investigation.
What are you referring to? Someone raising what?
The last part, that she felt that Free State did not address the issues that were raised with her.
Okay, yes.
I'm saying those must have been raised by parties that were external to the investigation.
No, I can only speak about the fact that those issues were raised by the public protector. I don't know of anyone external that would have raised them with her. Okay. Certainly not with us.
Okay, you know the difference between the word with and by. She's not saying Free State did not address the issues that were raised by her. She says the issues that were raised with her. That means by somebody else, correct?
It's possible, but I can't say that with certainty. I don't know. It's not within my knowledge that it was.
What is it you don't know? English. It's a preposition. It's a preposition, sir. The preposition, if it said there, which were raised by her, you would know what it means, correct?
That would be specific enough, yes.
And if it says, if it is raised with her, it means someone else raised it with her, correct? Simple English.
That's correct. It could be anyone, but I don't know who it could have been. It could have been someone internal, but not necessarily involved with this investigation.
That's fine.
All right.
That's fine. Don't worry. There's nothing that turns onto that. Okay. So it says, here's the point. It says, so at some point, it was a futile exercise to submit them to her because she was expecting Free State to make specific findings, which it seems were not captured in the Section 79 notices and the draft provisional report. So that one is clear. It became a futile exercise to even give her the reports because she was adamant about these findings, which you as investigators were not making, correct?
That's correct.
And so one can assume that it was not from laziness on your part. It's because you had nothing to implicate the people she wanted to be implicated. Otherwise, you would have done so, correct?
That's correct.
Thank you. Now, so this is what I'm talking about when I'm saying there was frustration. I was not putting it higher. Is this frustration? You'd accept that Mr. Makawa's letter there expresses some frustration, some form of frustration?
Yes, I would accept that.
Thank you. Right. Now, I'm then saying that the first time that at least we have a written indication or confirmation that there were findings made, and this also flies directly against your evidence that the public protector instructed you privately that she didn't want the politicians to be implicated. Can you go to 2261?
Yes, I'm there.
Right. You see, this is Ms. Celia writing to you.
That's correct, yes.
And she says, we've finished the report and we're starting the Section 79 letters. Correct?
Correct, yes.
We are making findings of maladministration against Premier and MEC. You see that?
Yes, I see that.
Therefore, 3 notices and 1 discretionary notice to the SIU. So this is the first time that it is now being directly proposed that the Premier and the MEC must be confronted with the findings of administrations against them, correct?
I wouldn't say that was the first time.
Thank you. No, you're right. Actually, it was not the first time, but that makes it worse for your theory. These letters had been mooted since March. And when I'm saying this is the first time that we have evidence that those findings had already been made, you agree, you would, I'm sure, that the letters, the Section 79 letters had been spoken about since March, correct?
That's correct.
Yes. So that's why I'm saying it's even worse for you. So 4 months or 5 months into the term of Advocate Mkhwebane, for the first time, we are writing to the Premier and the MEC specifically about the findings against them of maladministration, correct?
Whether it was the first time or not, I can't recall. But yes, based on this, it could have been the first time.
What other time, Mr. Samuel? It was the first time. Why do you want to run away from the obvious?
I cannot speak about the period before I was involved in the investigation. Yes, from the time that I was involved in the investigation, to my recollection, this was the first time.
Okay, I'm sorry, Mr. Samuel. Yes, but when you were involved, surely somebody gave you the history of what had happened, correct?
That's correct, yes.
And that person never said that there were Section 79 notices against politicians, correct?
I cannot recall that I would have been told about Section 79 letters. If that was the case, Section 79 letters are sent when we have finalized our investigation and we are likely to make adverse findings.
Absolutely. That's the point I'm making. I'm saying, therefore, you and I don't know why you're making these qualifications. You and I agree then that between March and June, when this letter was being returned, this was therefore the first time, that findings of maladministration directly against the Premier and the MEC were made, and therefore it follows logically, then they were entitled to Section 7(9) letters, correct?
That's correct, yes.
Yes. So this notion that the Advocate Mkhwebane was shielding politicians is completely baseless, because she was the first person for the first time, or rather under her regime, that there were direct findings of maladministration against the Premier and the MEC. Right. Now, this is then what happens, Mr. Samuel. After that, then in June, I think sometime in June, the 7th of June, indeed these Section 7(9) letters were dispatched, correct?
Yes, the Section 7(9) letters were dispatched, but I need, you see, you drew a conclusion before asking this question, which is a conclusion I want to
dispute.
Dispute and qualify.
Okay, fair enough.
So the first, when you're making reference to the first time findings being made of maladministration against the Premier and the MEC, you must bear in mind that those letters were only confined to the findings that had been made by the AG. That in the report of the AG, it was only confining it to those, not to their specific involvement, which they would have had to respond to in the letters that we had sent to them.
Okay, Mr. Samuel, yes, let me just be clear with you.
Yes.
I accept that what you and I earlier called something bigger. You remember that?
Yes, I remember that.
So believe me, I'm very clear on this. So all I'm saying to you is that the findings of any wrongdoing, direct maladministration, were made at this time that you and I have agreed, March and June, correct?
That is correct.
Yes. And I'm saying, in your view, it might have been that you think this is not sufficient, but at least it was something. It was something directly against them, correct?
That's correct.
And it was happening for the first time, correct?
That's correct.
Yes. However, Mr. Samuel separately felt that there is something bigger that they should answer for, correct?
That's correct, yes.
And it was in respect of that something bigger that Mr. Samuel wanted them to be subpoenaed, correct?
That's correct.
But Mr. Samuel would have been breaking the law because he would be subpoenaing them without them even known about something bigger, let alone this something medium that we're talking about. So the first time they would be hearing about the something bigger would have been in the phantom subpoenas.
I do not agree.
Okay, that's fine. Don't worry. We'll walk this path together. But so let's do it one by one. As far as the maladministration, so okay, let me put it this way. The attitude displayed to you in the private discussion with the public protector on the 10th of April was that she doesn't want any adverse findings against these politicians, correct?
Before I answer that question, can I just quickly get it from you, Chair, through you, Chair? Are you, in asking this question the way you do, are you saying the public protector now recalls that I was there, hence our attitude?
No, she doesn't. She refutes it with the contempt it deserves. I'm just saying that we don't have yet a proof because we're being frustrated. So we're working on your theory. because we can't wait for that. The chair won't allow me to say, let's stand down this cross-examination until we get those documents. If we have to recall you, we'll recall you. So for the sake of progress, I'm working on your theory. I'm saying even if you were there, which I don't accept, the attitude of the public protector, according to your theory, was that she doesn't want any adverse findings against these two politicians, correct?
That's correct. And that attitude was reflected in what she said, it was not something that I imagined. It's what she said in response.
Well, we don't agree on that one. Yeah. But let me say that how is that consistent with this letter from Ms. Lear saying to the public protector, we are making findings of, or to you, by the way, we are making findings of maladministration against the Premier and the MEC. Didn't you say to her, but the public protector doesn't want any adverse findings against these people, you are going to be fired?
No, she knew that because I had told her that the public protector didn't want any findings made against the public protector, the politicians.
And yet she was bold enough to write this letter, basically saying the public protector can go and jump.
Based on the information she had and on what she was referring to there. There was nothing wrong with what she said. I didn't find anything wrong.
No, I know, Mr. Samuel. I'm saying, you've been told privately by the public protector, and you've told your colleague. She writes to you on the 24th of April, basically saying, the public protectors, I don't care what she says, I'm doing this. Where is the part where you say, Ms. Elias, do you know that you're playing with fire? I'm sitting here with an instruction not to implicate these people in anything.
Chair, you want to put words that I should have said to Advocate Siye. Words like she can go and jump or she must disobey. No, I did not do that.
Okay.
That is the net effect of what happened. By putting them in the letters, yes, it was a defiance, but not that we discussed that defiance. No.
No, fine. Forgive me for when I say I'm just exaggerating for effect, but I'm happy with your word there. So you are saying this letter was being written in defiance?
It defied the instruction she had said, we must not fight against politicians, yes.
And the defiance was, Ms. Leah was defying knowingly because you had told her about the instruction.
Yes, I would say so, knowingly but not maliciously, but because she was basing it on the facts that were there before her, and that was based on the AG report.
Okay. Then you have a couple of, about 10 days later, this is the person who's being defied now. At 2401, Chairperson, at SS 22.
Can you see it? There it is.
Is the one below? One below, please. Yes. The public protector writes to you and Ms. Elias, the Defiance campaign. And she says, good afternoon. Can I have an explanation as to why I was requested to sign the Section 7.9, which omitted issues the Premier and the MEC should respond on? Which means she knows that the Section 7.9 there, but she's saying that there are some omissions. Does that make sense to you, Mr. Samuel? This is the person who's now being defied, basically saying, make it better, the Section 7-9 letters.
Chair, I just want to, before I answer that question, I want to, yes, I just wanted to satisfy myself that what I can recall is in fact the case here. And what I can recall is that this was after the Premier had suggested that information or attachments that we were referring to in the Section 7-9 letter were not attached and so needed to be provided to him so that he can make an informed response to the Section 7-9.
Yeah, no, that's correct. That's my instructions as well. Yeah. But that's not what I'm asking you. What I'm asking you is that what this letter should be saying is that, Mr. Samuel, because it's to you as well, don't you know that I told you that you mustn't implicate these people? It can't be saying, why have you omitted certain information from the Section 7-9? Because this is the person that you and on your strange version and Ms. Celia are now busy defying. Do you understand what I'm asking you?
I understand what you're asking me, but
what is the answer?
If you look at the next sentence, it says, I took it, we're sending the Section 7-9 for their information on the findings against the HOD. So yes, it was that information that she was querying.
No, sir. I'm saying to you, whatever that information was, but the point I'm making to you is that she's aware that there are Section 7-9 notices, which means these people are now being directly accused of something. B, she's asking why that certain information is omitted, not why you have issued those letters, but why they are, let's put it like this, incomplete. Correct?
It was only the attachments that were being referred to here. It was not the information in the Section 7-9.
Mr. Samuel, please don't play games with us. The attachments were part of the Section 7-9 letters that Ms. Celia had been referring to at 2261, where she says, we are making findings of maladministrations against the Premier and the NEC. Were they not?
You've seen that we're sending the Section 7-9. Yes, they would have had to be
Thank you. Yes. Remember, this is about 12 days later after that letter. All I'm saying to you, okay, anyway, I don't have to debate this with you. I'm going to argue that your evidence is just completely senseless, that the objective evidence that I'm putting to you doesn't go along with this, with either your so-called request for subpoenas, which defy the 3 strikes rule, as well as the alleged response by the PP that she doesn't want these people to be implicated in anything. Because here it's happening in front of her, and she's not protesting. Actually, she's aiding and abetting the process and wanting the Section 7-9 information to be expedited. That's what I'm going to argue. You can comment if you like, but I'm not going to go around in circles with you.
Chair, if I'm to comment on that, I will repeat what I said, that this was only in relation to the attachments that were not attached to the Section 7-9. And perhaps if we go down, up to the email exchange there.
Yes. Okay.
That would have been brought about by the letter that the Premier wrote to the public protector to bring it to her attention that information is not attached that I should refer to. I should respond.
Yeah, but that's got nothing to do with what you and I are discussing. Anyway, let's move on. So eventually, after all these things were fixed, you agree that the public protector signed the Section 7-9 notices.
My understanding is that at that time, when this was written, she had already signed those Section 7-9 notices.
Yes, with the defects. I'm saying once the defects had been resolved, the letters were then sent to the Premier and MEC, correct? And the HOD, of course.
No, the letters had already been sent. They were in their possession. It is only the attachments that were sent subsequent to her signing and dispatching these letters.
Yes, that's even better. That's even better for me. I'm saying the public protector had, according to you, earlier signed the Section 79 notices, correct?
That's correct, yes.
Yes. And the Premier and the MEC responded thereto, correct?
I do not recall with the MEC, but I certainly do recall the Premier responding, yes.
Right. And the Premier's response, where is it? Have you seen it?
Yes, I saw it because I think a copy was sent through to us as well, of the response. But the response was done directly to the public protector, the private office.
To head office, yes.
Yes.
Right. And sorry, Chairperson. Okay, sorry, thank you, Chairperson. Sorry, I was just taking instruction. You will recall then that Mr. Mahashule at least gave a long explanation, I think about 12 or 13 pages in response, correct?
Yeah, I recall that he responded, but I can't recall how long his explanation was.
Okay, you might not recall its length, but at least you might recall its content, that it gave explanations, correct?
Yes, it did, but I can't recall the contents, not without the fact.
Okay, you can't. Okay, fair enough. You can't recall what explanations he gave to what was being suggested in the Section 79 letters, correct?
Yes, that's correct.
Yeah. Now, explain this to the committee then. How is it that you can say that, or let me put it this way. The purpose of Section 79 is to give out the alteram pactem, correct?
That is correct.
In other words, if I'm implicated in some wrongdoing, the public protector has been criticized in the CR17 matter, for example, to say that she did not comply with Section 79. You'll recall that. That's one of the cases you cite in your affidavit, correct?
Correct.
Yes. So here, Section 79, the reason why there is this, the courts feel so strongly, is because they say, as Mr. van Lochenberg was at pains to tell us, if he had been given a chance to respond, maybe the outcome would have been different, correct?
Correct.
In other words, the response, you cannot, how are you able to say to this committee that the non-inclusion of the Premier is wrongful if you don't know what his response was? What if he says, I was not even in South Africa at the time? I don't know what you're talking about. What must the public protector do? Still comply with Advocate Madonsela's wishes?
No, that is not what I'm saying.
Yeah. No, okay, fair enough. Maybe I'm putting words in your mouth, but you understand the proposition I'm making. I'm saying if you sitting here, Mr. Summer, do not even know what the counter or the evidence that was counter evidence that was produced by the recipients of the Section 79. You know that the Section 79 is meant to either implicate you further or to exonerate you, correct?
That is correct, yes.
Yes. So let's work on the assumption then that there was exculpatory evidence in those responses. What was the public protector supposed to do? Still include them just because they are politicians?
Chair, an omission of information, whether it absolves the person implicated or it makes it, the situation worse, or it doesn't convince the public protector that sufficient information exists to be persuaded otherwise than what she would have said in the Section 79. It would have to be reflected in the report that we sent Section 79, this was the response, these were the allegations, this was the response. As a result, we do not find, that we find that the premier is innocent of what he was accused of. That is supposed to be in the final product to show that at least that response was considered. As to what its value is, it's something else. And my understanding from what a previous witness has said is that all information related to the premier was removed.
Mr. Samuel, please. Don't worry about the previous witness. You have testified here. You have accused the public protector of pursuing personal agendas, political agendas, and so on. We've now established that this same person you've been accusing of was the first person to actually implicate politicians, was the first person to rightfully give them their Audi alteram partem rule rights. So I'm saying to you, the evidence of the public protector will then be that, as it happens with all other witnesses, once the Section 79 response is to her satisfaction on a particular point, then if she actually then includes the person and implicates them, that's when she will be reviewed. Would you agree?
Yes, I agree. It's meant to convince her, yes.
Thank you. All right. Now, let's move on to what I call your bias and your your perjury. I'll do this by let's start with your evidence where you say that your intentions of doing the initial affidavit were not connected to the impeachment process. You remember that evidence?
Yes, I do.
You stand by it?
Yes, I do.
All right. And you stand by it despite the fact that, according to your paragraph 11 of your affidavit, you are saying that the impeachment process flowed from your initial affidavit.
So you said paragraph 11.
11, yeah. You'll find that on page 20.
I thought you were referring to the initial affidavit. All right. Where will I find that?
No, you are referring to the initial affidavit in your second affidavit.
All
it's
right.
Page 2072. It's It's where you link your initial affidavit directly to this process, where you also falsely refer to the rules that you've never read.
Yes, I do.
You do what?
I do concede that I make reference to the committee's rules, which I
yes. So your evidence that the initial affidavit was not done with this impeachment process in mind is false.
No, it is not false. I do concede that I had not read the rules, but I do, that is not to say that the rules were not communicated to me and the affidavit prepared in terms of those rules, in compliance with the rules. I had no reason to doubt that the advice I was getting from the committee, from the evidence leaders, would be false simply because I had not read the rules.
Mr. Samuel, you are fudging now. Let's break it down. The impression that in this paragraph that you have read the rules is false.
There is no way on this affidavit where I say I've read the rules.
No, but you imply, when I say the impression, where you say, I deemed it necessary, especially in light of this committee's rules. Surely a reader of that will mean you deemed it necessary in view of the rules which you must have read. You can't say in light of the Bible if you've never read it. Okay?
I do not agree, Chair. The rules could have been brought to my attention in any other form other than me reading them.
Yes, but when you say...
When a person jumps to the conclusion that I've read the rules simply because I refer that, saying, especially in light of this committee's rules, that is that person's conclusion, and it's not my conclusion. It's not how that information is received. I really have no control. I have control over what I say, and that's what I said in my affidavit.
Yeah. All right. Anyway, what I was saying to you is the impression, the further impression that you created to this committee, that the initial affidavit was done without any view to or any connection or wishes to influence this particular process was false.
In my initial affidavit, yes, the process, as far as I can recall, had not started. So I did not have the intention of it being referred to any committee or at least this committee. Any committee, yes, I might have been happy with it in the sense that I was only asking for an investigation.
That's a lie. That's yes.
Not false.
I understand. No, okay, let me put it stronger than being false. It's a lie. What do you say to that?
I deny that.
Okay. You said in an interview with the SABC that you wanted that affidavit was intended for this committee or this process, didn't you?
To the extent that my affidavit was referred to the portfolio committee, that was my belief at the time, and I believe that it was the portfolio committee that was going to be looking at my complaint.
No, that's another lie. No, you said it must be referred to the committee that will be dealing with the impeachment process. I might not be using the exact words, which you correctly identified as a separate committee. So you're lying now, right now.
I'm not. I deny that.
You deny?
I deny that I'm lying.
Yes. Okay, well, you lied either to Mr. Peter Ndoro or you're lying to the committee. I think it's better for you to keep yourself out of jail. It's better if you are lying to Mr. Peter Ndoro, because now you are under oath.
Okay.
Just a pause, Honorable Milam.
Thank you, Chair. I follow what Advocate Mpofu is doing. I just want to know, is that interview going to be played? Are we going to hear that interview? You know, it's being referred to, but we have no evidence here before us except for what Advocate Mpofu is saying. So I'd like to hear that interview, please.
Yeah,
Thank you, Honorable.
Thank you. Am I still on?
Advocate Mpofu.
Yes, thank you, Chair. Yes, Honorable Member. Yes,
that you'll be able to share that with us.
Yeah, I will. If I can first cross-examine the witness, it will be done just now. Yeah.
Okay, go ahead.
Thank you, Chair. Yes.
We will come back to it.
Yes, we will come back to it. I'm just, yes, sorry, I was just disturbed. And you also, in the same interview, repeated the insults that you made against Advocate Mkhwebane. And I'm not, as they say, you must let bygones be bygones. I know you've since apologized for that, but I'm saying that those were also contained in the interview. You remember that?
In the interviews, I confirmed what I had said in my affidavit.
Yes. And you also called upon your colleagues to rise up, okay, that's my word, but to basically join your acts of defiance, correct?
I made the statement that my colleagues should not be speaking to me because I have come forward. They must also, on their own, come forward with the information that they were relaying to me. That was that. That was what I was saying. I was not, as you probably put it, I was not inciting them. I'm saying it because you may not have used the word inciting, but certainly that was the charge against me. I was not inciting them. I was just saying the information that you relaying to me, come forward with it because you have it, not I.
Yes. And you also, despite the discussion that you and I have just had, you falsely accused her of having interfered in the Friede report.
I deny that I falsely accused her. I stand by what I testified about her involvement in the Friede report.
And you also falsely made the statement that Advocate Madonsela was not, or rather did not get involved in litigation where the reviews were successful.
That is not what I said. I said where the office during her time got involved in litigation, it was with circumspection, in the sense that we weighed our chances of success and always had this in mind that we were not necessarily a litigious institution.
Do you know that Advocate Madonsela lost many cases which were reviews, which were also mounted against her?
I don't know the number, but yes, I'm aware that she lost some cases.
And do you know that unlike what is supposed to happen here, some of those judgments were also what you might call scathing against her?
In relation to, or in comparison to the cases that Advocate Mkhwebane lost, I do not recall them being scathing towards her. Certainly not as far as the her knowledge of the application of the law and so on are concerned.
Okay, well, at least one of the judges, you might not be aware thereof, but in the case, for example, just as an example of SA Bureau of Standards versus the Public Protector, this is what Judge Potterly had to say, and that is also loaded, Mr. Malam. So there's no rational connection between the withdrawal of the mark SABC being ordered to assist Prabudas, which has a company, to reopen a business to manufacture a further 150,000 order to establish a business. A further 150 ordered by the public protector to re-establish a business is quite astounding. And then she went on to say that the vague and nondescript unobtainable remedy ordered by the public protector leaves one dumbfounded and needs no further address. Those types of remarks were the types of remarks that are supposed to be causes for impeachment now. Do you remember that?
Yes, I remember that, but as I say, they were not scathing to the extent that they went to her knowledge of the application of the law. They were only scathing in relation to the rationale behind making those remedial actions.
Is rationality not the law in your estimation?
No, the law should be, yes, it is supposed to be rational, yes.
Yes, but
it doesn't. But those words were not specifically uttered by the judges, certainly the effect that those words had subsequent to that judgment did not have the same effect to the office as the ones made against Advocate Mkhwebane.
Okay, and whose fault is that? If the media decided to not to highlight those remarks and decided to, for the whatever purposes they have, highlight them in relation to Advocate Mkhwebane, who must be impeached, the media or Advocate Mkhwebane?
I cannot speak on behalf of the media, but certainly it would be ridiculous to impeach the media. And I'm not saying, I do not have control over what their interest is, in a particular story. So,
fair enough.
Yeah.
Yes, no, I accept that. So, but you'd agree that it would be equally ridiculous to impeach Advocate Mkhwebane simply because in her case, the scathing remarks were highlighted, but in the case of Advocate Madonsela, the scathing remarks were not highlighted. You'd agree that's actually ludicrous.
I would distinguish that, by saying the cumulative effect of not only one judgment, but quite a number of them against Advocate Mkhwebane, borne by the fact that she was becoming more litigious in relation to what Advocate Madonsela was, exposed her to those kind of comments being made. And that was the effect of the cumulative effect of her attitude towards litigation.
No, fair enough. I accept I understand what you're saying. But I'm asking you a simple question. Assume that is so. I'm saying, where do you lay the blame? Do you punish the victim of those remarks being highlighted, or do you punish those who make them? So in other words, if I say, Mr. Samuel, if you and I do exactly the same thing, but somebody says, no, it's Mr. Samuel's fault, but Mfu is an angel, but you and I have done the same thing. Do I blame you, Mr. Samuel, or do I blame the person who's giving a skewed picture?
I cannot comment on that one. I was not involved in in the highlighting of these judgments.
Fair enough. That's fine. But you would agree, therefore, that you and I had already agreed, I think, that the Nkandla judgment was a turning point in this litigation journey of the public protector, correct?
Yes, to the extent that it took place and did not necessarily mean that that was the only time that litigation was taken against the office. Yes.
No, I understand. I'm just saying, but it was at that point.
It had an effect. It had an effect. That much I'm concerned.
Yeah. It had a major effect in the sense that for the first time, the court had pronounced that remedial action was binding now.
That's correct, yes.
Yes. And according to Advocate Madonsela herself, that was going to then create a new avalanche of litigation. Avalanche is my word. It was to create a new, let's call it traffic or volumes of litigation. That was obviously predictable, correct?
I cannot recall Advocate Madonsela saying that, but if you want my opinion as to whether that was the effect, I will honestly say yes. It was one of the one of the factors that catapulted our office into being taken more on review because it then meant that whoever this was implicated in these reports, could not ignore them any longer.
Okay, can we go to bundle B? Bundle?
Can you just refer me to a page? I don't have the bundle numbers on it.
Oh, okay. I'll ask them to put it up. I think it's bundle F, page 31, paragraph 2.1. Bundle F, item 1, I'm told.
Advocate Bauer, that's
Can you tell us what you're referring to, Advocate Mpofu?
It's the annual report of 2015 to 2016 of Advocate Madonsela.
Yeah, bundle 1. Sorry, what was your page reference?
It was bundle F, item 1, page 31, paragraph 2.1. Mr. Samuel, did you read annual reports? Was that part of your job?
Yes, I did.
Okay. So I'm going to read out what Advocate Madonsela said. This is the annual report of 2015-2016, long before the dreaded Advocate Mkhwebane was even in that office. This is what it says, quote, the significant ruling, are you with me? Can you see that part on the screen?
It's not on the screen, I just, I don't see it on the screen.
Okay, thanks.
It is now.
It is on the screen.
It is now.
Screen share, Honorable Operator.
It's there. Can you see it, Mr. Samuel?
Or is it the paragraph just before 2.2? Yes.
Yes,
that's a paragraph. Right. Thank you. Yes.
Okay, I'll read it out for the record and then I'll ask you to comment. All right. She says, the significant ruling by the Constitutional Court, that would be the EFF Nkandla case, okay, clarifying the extent of the public protector's powers poses two significant challenges. The main challenge and risk the institution faces is an increasing number of state institutions taking the public protector's reports on judicial review. As a result, the public protector is forced to defend these matters, resulting in a massive financial burden to the institution. Another potential risk may be an increase of complaints stemming from the judgments now that there is clarity on the binding effect of the public protector's remedial action. If I say it, maybe you don't agree, but I'm sure if it's Advocate Madonsela, you will agree. Do you go along with that statement as a statement of fact?
Yes, I do.
Does that have any implication to you in your mind on what you call what you decry as an undue increase in litigation that actually was attributable to what Advocate Madonsela was saying?
Advocate Madonsela identified this as a major challenge and a risk, but not necessarily as a fact, as at the time this report was prepared. And my gripe is, and I've testified to this effect, that the fact that you are being taken on review does not necessarily mean that you must defend everything that is being reviewed. If you are certain that you have done it, that's it. I mean, you don't have to be involved in defending any litigation unless it is meant to protect and you sure that it is in the interest of the organization.
So Advocate Madonsela was talking nonsense when she says, as a result, the public protector is forced to defend those matters.
Those were her words, not mine.
Yes.
I can't comment. I can't say that she was talking nonsense. No.
Okay. Sorry, maybe.
It was certainly not the policy of the office to defend all the cases.
Okay, so you disagree with Advocate Madonsela?
To the extent that you seek to put it that she was forced to defend all and any litigation that was being launched against the office, I do not agree with you. That would still have to be decided on each particular case, on the merits of each particular case, and whether or not it is really going to be to the interest of the office.
Okay, so
that did not open the floodgates to defend anything.
Okay, Mr. Simon. So that means I'm obviously not your hero. Because now you are blaming me you are just so scared of blaming Advocate Madonsela. It's not me, Mr. Samuel. I'm reading what she said. Don't kill the messenger. She said, as a result of the public protector is forced to defend these matters. Now you're saying you're disagreeing with me. What have I done?
No, I'm disagreeing with the suggestion that, implied in what you're saying that, she meant that we're forced to defend all and every case that was brought against us. What I'm saying is that is done in by looking at each case on its own merit. And we certainly, even during a time, did not defend all reviews that were brought against the office.
Mr. Samuel, I'm not a witness here, but when the public protector comes to testify, she will give you a number of matters where she was advised by me and other people to take matters to court or an appeal or whatever, and she declined on several occasions. So and I know you might not know about that, but I'm saying to you, this notion of yours that she was defending every case or taking every case up is false. Can you at least accept that, or she'll dispute it?
If you put, if she puts evidence that she did dispute some, I won't have any reason to dispute that.
Good. And if that happens, then will you be man enough to alter this accusation that she was taking every matter to court? As I say, even when she was advised, she wouldn't take matters. I'll give you an example. You've read the matter of the commissioner for SARS. I think you were referred to it. It's one of the subsequent matters, not the one you referred to. But it was a matter about a subpoena to the commissioner for SARS. You might be aware just generally.
Yes, I am generally aware.
Yes.
Yes.
Yeah. Now, in that matter, you know that on the merits, the court suggested that that issue could be taken by challenging the particular section. In fact, in other words, on the merits, what the court decided was to deny the public protector direct access. You know what that means?
Yes, I do.
Yeah, what that means is that if you had denied direct access on appeal, what you should actually do is to go to the SCA first, broadly.
Yes.
Yes. And then there was a second appeal that the public protector had done against an adverse cost order and disparaging remarks or scathing remarks. She succeeded as far as that part was concerned. You remember, I don't expect you to know the case in details, but you remember generally, yes.
Yes.
And the advice she was given by her legal team was that that challenge should be done in the SCA as suggested, at least indirectly, by the Constitutional Court. And she declined that. I'm just giving you that as an example. You'd accept that those are not the actions of someone who's reckless.
If it is proven in this hearing and you know it goes against what I said, I would consider the matter. Yes.
Yes, and you accept.
Advocate Mpofu. Advocate Mpofu.
Yes, Chair. It's lunch, Chair. Can I please just go to this last question?
Okay. No, it's fine. Go ahead.
Yes, thank you, Chair. It's just so that we round it off at a logical place, Mr. Samuel.
Sure.
Yes, I'm saying, Mr. Samuel, what I've just told you, the example that I've just given you, is also consistent with the proposition that I'll put to you after lunch, namely that the public protector in most cases is defending the matters. She's the one who's taken to court. As Advocate Madonsela was saying here, the public protector is forced to defend these matters, in other words, to defend her reports. If I demonstrate that to you after lunch, will you also reconsider your theory on so-called reckless litigation?
Yes, to the extent that it disproves that, but I think you must also take into account that I spoke about the cumulative effect of these judgments that was given to us.
Okay, thank you. Let's leave it at that for now. Thank you, Chairperson.
Thank you, Advocate Mpofu. Thank you, Mr. Samuel. Honorable colleagues, we adjourn for lunch back at 2.
Recording stopped.